Anti-terrorism legislation are laws with the purpose of fighting terrorism. They usually, if not always, follow specific bombings or assassinations. Anti-terrorism legislation usually includes specific amendments allowing the state to bypass its own legislation when fighting terrorism-related crimes, under the grounds of necessity. Because of this suspension of regular procedure, such legislation is sometimes criticized as a form of lois scélérates which may unjustly repress all kinds of popular protests. Critics often allege that anti-terrorism legislation endangers democracy by creating a state of exception that allows authoritarian style of government. Anti-terrorism in the 19th century. At the end of the 19th century, Russia, Europe and the United States were confronted to a new radical movement which engaged in violent and illegal acts. This movement was first created in Tsarist Russia, where young intellectuals, sometimes staunch positivists, began to engage in a violent struggle against the Tsar. Finding their influence in Nikolai Chernyshevsky's What Is to Be Done, they began to advocate assassinations and bombings. One of the first group, Zemlya Volya, formed of upper-class professional revolutionaries, started armed struggle against the Tsar's regime. Sergei Nechayev would become one of the most famous figures of what quickly became known as a nihilist movement, whose fate was described by Albert Camus in The Just Assassins. Camus would later write a thoroughly thought-out essay on existentialism, rebellion and the use of violence in history in The Rebel, which denounced both quietism and terrorism. Russian nihilists eventually succeeded in assassinating Alexander II in 1881. The nihilist movement then quickly spread to all of Europe, in particular via one of the founder of anarchism, Mikhail Bakunin, who fled to Switzerland, a haven for political refugees of the time. There, he joined the First International, which eventually theorized propaganda of the Deed. Starting in the 1880s, a wave of bombings and assassination attempts, organized by people close to the anarchist movement, literally began to terrorize the governing classes. Propaganda of the Deed was not necessarily violent action, but often took that form, spinning on the right of rebellion, which had been theorized centuries ago by liberal thinker John Locke. Such anarchists had no moral problems in theorizing regicides and tyrannicides, since it was for the good of the people. Bakunin thus wrote that, "We must spread our principles, not with words but with deeds, for this is the most popular, the most potent, and the most irresistible form of propaganda." As soon as 1887, several anarchists opposed themselves to what they saw as a self-defeating tactic, including Peter Kropotkin, who wrote that year in La Révolte that it is an illusion to believe that a few kilos of dynamite will be enough to win against the coalition of exploiters. Kropotkin's pragmatism eventually proved to be more realist than the most radical anarchists' idealism. Soon, all the labor movement was confronted to strong repression from the state, which did not manage to convince the people to start an insurrectionary and general strike, as had been expected by the theorists of propaganda of the Deed. Furthermore, as depicted in Joseph Conrad's novel, agent provocateurs also infiltrated the movement, permitting many arrests in the social movement. In France, after Auguste Valent's attempt, the opportunist Republicans voted in 1893 the first anti-terrorist laws, which were quickly denounced as lois scélérates. These laws severely restricted freedom of expression. The first one condemned apology of any felony or crime as a felony itself, permitting widespread censorship of the press. The second one allowed to condemn any person directly or indirectly involved in a propaganda of the Deed Act, even if no killing was effectively carried on. The last one condemned any person in newspaper using anarchist propaganda. 1. Either by provocation or by apology, encourage one or several persons in committing either a stealing, or the crimes of murder, looting or arson. 2. Or has addressed a provocation to military from the Army or the Navy, in the aim of diverting them from the military duties and the obedience due to the chiefs, will be deferred before courts and punished by a prison sentence of 3 months to 2 years. Thus, free speech and encouraging propaganda of the They or anti-militarism was severely restricted. Some people were condemned to prison for rejoicing themselves of the 1894 assassination of French President Sadi Carnot by the Italian anarchist Caserio. The trial of the 30 took place in 1894, at the issue of which almost all the defendants were acquitted. The term of lois scélérates has since entered popular language to design any harsh or unjust laws, in particular anti-terrorism legislation which often broadly represses the whole of the social movements. The United Kingdom quickly became the last haven for political refugees, in particular anarchists, who were all conflated with the few who had engaged in bombings. Already, the First International had been founded in London in 1871, where Karl Marx had taken refuge. But in the 1890s, the kingdom became a nest for anarchist colonies expelled from the continent, in particular between 1892 and 1895, which marked the height of the repression. Louise Michel, aka the Red Virgin, Émile Pouget and Charles Matato were the most famous of the many anonymous anarchists, deserters of simple criminals who had fled France and other European countries. A lot of them returned to France after President Félix Faure's amnesty in February 1895. A few hundred persons related to the anarchist movement would however remain in the UK between 1880 and 1914. The right of asylum was a British tradition since the Reformation in the 16th century. However, it would progressively erode itself, and the French immigrants met with hostility. Several hate campaigns would be issued in the British press in the 1890s against these French exiles, relayed by riots and a restrictionist party which advocated the end of liberality concerning freedom of movement, and hostility towards French and international activists. Could the kingdom continue to provide haven for activists which did not confine themselves to opposition in one single country, but which travel from country to country, theorizing an international revolution? Thus, strong debates began to shake the island, which finally decided to restrict freedom of movement. Thus were created one of the first immigration control laws. In a wholly different context, the same kind of debate would be lifted at the end of the 20th century, with the resurgence of international terrorism, this time under the guise of Islamic terrorism. International conventions related to terrorism and counter-terrorism cases. Terrorism has been on the international agenda since 1934, when the League of Nations, predecessor of the United Nations, began the elaboration of a convention for the prevention and punishment of terrorism. Although the convention was eventually adopted in 1937, it never came into force. Today, there are 15 counter-terrorism international conventions in force. They were developed under the auspices of the United Nations and its specialized agencies and the International Atomic Energy Agency. Moreover, on the 8th of September 2006, the UN General Assembly adopted a global counter-terrorism strategy. Conventions open to all states. 1963 Convention on Offenses and Certain Other Acts Committed on Board Aircraft. 1970 Convention for the Suppression of Unlawful Seizure of Aircraft. 1971 Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation. 1973 Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons, 1979 International Convention Against the Taking of Hostages, 1980 Convention on the Physical Protection of Nuclear Material, 1988 Protocol for the Suppression of Unlawful Acts of Violence at Airports Serving International Civil Aviation, 1988 Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, 1988 Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platforms Located on the Continental Shelf, 1991 Convention on the Marking of Plastic Explosives for the Purpose of Detection, 1997 International Convention for the Suppression of Terrorist Bombings, 1999 International Convention for the Suppression of the Financing of Terrorism, 2005 International Convention for the Suppression of Acts of Nuclear Terrorism, 2010 Convention on the Suppression of Unlawful Acts Relating to International Civil Aviation, 2010 Protocol Supplementary to the Convention for the Suppression of Unlawful Seizure of Aircraft, a 16th International Convention. A proposed comprehensive convention on international terrorism is currently under negotiations. Security Council Resolutions UN Security Council Resolution 731, UN Security Council Resolution 748, UN Security Council Resolution 883, September 28, 2001 United Nations Security Council Resolution 1373 adopted under Chapter 7 of the United Nations Charter, which makes it legally binding to member states. Among other provisions, it favored the exchange of intelligence between member states and legislative reforms. It established the United Nations Security Council Counter-Terrorism Committee to monitor state compliance with its provisions. Later resolutions concerning the same matter were UNSC Resolutions 1390, 1456, 1535, 1566, and 1624. Regional Conventions. Europe 1977 European Convention on the Suppression of Terrorism. 2003 Protocol. 2005 Council of Europe Convention on the Prevention of Terrorism. Commonwealth of Independent States Treaty on Cooperation among States members of the Commonwealth of Independent States in Combating Terrorism. The Americas Organization of American States Convention to Prevent and Punish Acts of Terrorism taking the form of crimes against persons and related extortion that are of international significance. Inter-American Convention Against Terrorism (AGRES). 1840. Africa Organization of African Union Convention on the Prevention and Combating of Terrorism and a Protocol to the Convention. Addis Ababa, July 2004. Asia SAARC Regional Convention on Suppression of Terrorism. Additional Protocol to the Convention. Islamabad, January 2004. The ASEAN Convention on Counter-Terrorism, Cebu, Philippines, the 13th of January 2007. League of Arab States Arab Convention on the Suppression of Terrorism. Organization of the Islamic Conference Convention of the Organization of the Islamic Conference on Combating International Terrorism. Anti-terrorist legislation in the European Union. European Union EU Framework Decision on Terrorism. European Court of Human Rights cases related to anti-terrorist legislation. Anna Marifidou v. Sweden 1981. Brogan and others v. The UK 11209 84ths, 11234 84ths, 11266 84ths. ECHR 24. Belgium Anti-Terrorism Act 2003. France. France has passed a variety of anti-terrorist laws, the first of which being the 19th-century lois scélérates restricting freedom of expression. Today, magistrates in the Justice Ministry Anti-Terrorism Unit have authority to detain people suspected of conspiracy in relation to terrorism, while evidence is gathered against them. Ireland Offences Against the State Acts Chapters 1939 to 1998 via the Special Criminal Court. Criminal Justice Act 2005. Italy passed various anti-terrorist laws during the years of lead in the 1970s. The Real Act was adopted on the 22nd of May 1975. It allowed the police to carry out searches and arrest persons without being mandated by an investigative judge. Interrogation could take place without the presence of a lawyer. Critics underline that this contradicted Article 3 of the Constitution on equality before the law. Preventive detention was fixed before 1970 to 2 years, for a possible sentence going between 20 years to perpetuity, while it was limited to 1 year for charges of crimes leading to a sentence of less than 20 years. It passed to 4 years after 1970. A decree law of the 11th of April 1974 authorized a 4 years detention until the first judgment, 6 years until the appeal, and 8 years until the definitive judgment. In case of indictment for acts of terrorism, the preventive detention was extended to 12 years. Because the decree law was passed on the 15th of December 1979. It prolonged the length of preventive detention relative to terrorism suspicions and allowed wiretaps. Critics have pointed out that this violated Articles 15 and 27 of the Constitution. The Cossiga decree law also created the status of pentito, those accused of terrorism crimes and who accepted of confessing them and of informing the authorities about their accomplices could be liberated. United Kingdom Prevention of Terrorism Act 1974-89. Terrorism Act 2000. Anti-Terrorism, Crime and Security Act 2001. The Prevention of Terrorism Act 2005 was intended to deal with the Law Lords ruling of 16 December 2004, that the detention without trial of 9 foreigners at HM Prison Belmarsh under Part 4 of the Anti-Terrorism, Crime and Security Act 2001 was unlawful, being incompatible with the European Convention on Human Rights. It was given royal assent on the 11th of March 2005. The Act allows the Home Secretary to impose control orders on people he suspects of involvement in terrorism, which in some cases may derogate from human rights laws. In April 2006, a High Court judge issued a declaration that Section 3 of the Act was incompatible with the right to a fair trial under Article 6 of the European Convention on Human Rights. The Act was described by Mr. Justice Sullivan as an affront to justice. Amnesty International, Human Rights Watch, Justice and Liberty have opposed it. Criticism of the Act included complaints about the range of restrictions that could be imposed, the use of closed proceedings and special advocates to hear secret evidence against the detainee, and the possibility that evidence against detainees may include evidence obtained in other countries by torture. The Terrorism Act 2006 increased the limit of pre-charge detention for terrorist suspects to 28 days after a rebellion by Labour MPs. Originally, the government and Prime Minister Tony Blair had pushed for a 90-day detention period, but this was reduced to 28 days after a vote in the House of Commons. Home Office Minister Damian Green announced on the 20th January 2011 that the period would revert to 14 days as the order extending the period to 28 days would be allowed to lapse at midnight on the 24th of January. The Counter-Terrorism Act 2008, a section of which would have controversially increased the limit of pre-charge detention for terrorism suspects for 42 days. This measure was dropped from the bill after it failed to win approval in the House of Lords. Terrorist Asset Freezing Act 2010, which led to the Terrorist Asset Freezing etc. Act 2010. Terrorism Prevention and Investigation Measures Act 2011 received royal assent on 14 December that year. Counter-Terrorism and Security Act 2015. UK anti-terrorism legislation is subject to regular review by the Independent Reviewer of Terrorism legislation. Anti-terrorism legislation in common law countries. Australia. Australian anti-terrorism legislation 2004. Australian Anti-Terrorism Act 2005. The Civil Rights Network opposes such legislation. Elizabeth Evatt, a federal judge, has criticized John Howard's 2005 anti-terrorism bill, particularly provisions relating to control orders and preventive detention, saying that these laws are striking at the most fundamental freedoms in our democracy in a most draconian way. Canada. Canadian Anti-Terrorism Act 2001. Bill S-7, the Combating Terrorism Act 2012, Bill C-51, the Anti-Terrorism Act 2015, India. Terrorist and Disruptive Activities Act, Prevention of Terrorist Activities Act, Unlawful Activities Prevention Act, New Zealand. Terrorism Suppression Act 2002. Pakistan. Bangladesh Anti-Terrorist Act 2009 passed in Bangladesh. This act is effective from the 11th of June 2008. Under Section 28 of this act, Anti-Terrorist Special Tribunal is trying the crimes. Further information http BD Laws, Minlaw, Gov, BD, Bangla _all_ sections, php, id = 1009 Suppression of Terrorist Activities Ordinance 1975 enacted by Zulfikar Ali Bhutto. The law remained in force in the Sindh province and the Punjab province until its repeal in 1997, and remained the law in the Northwest Frontier Province and Balochistan until August 2001. 1997 Anti-Terrorism Act, signed on August 17, 1997 by then Prime Minister Nawaz Sharif. The law, which included a broad definition of terrorism, was enacted after a January 1997 bombing by Mehrem Ali, a member of the Shia militant organization Tehrik-Nifas Fiqh-i-Jafaria. The Anti-Terrorism Act created specials anti-terrorism courts as well as an anti-terrorism appellate tribunal. Mehrem Ali was subsequently tried before those special courts, but made an appeal to the Supreme Court, which confirmed his death sentence, but declared most of the 1997 Anti-Terrorism Act unconstitutional. The 24th of October 1998 Anti-Terrorism Ordinance issued by Nawaz Sharif's government to respond to most of the Supreme Court's objections. According to political scientist Charles H. Kennedy, special anti-terrorism courts remained in place, but the judges of such courts were granted tenure of office. The special appellate tribunals were disbanded. Appeals against the decisions of the anti-terrorism courts would henceforth be to the respective high courts, and restrictions were placed on the earlier Act's provisions regarding trial in absentia to accord with regular legal procedures. Pakistan Armed Forces Ordinance 1998. Applying itself to the Sindh province, the ordinance granted broad judicial powers to the military. It also created the new crime of civil commotion, which exposed to a penalty of 7 firm prison years. The ordinance defined civil commotion as creation of internal disturbances in violation of law or intended to violate law, commencement or continuation of illegal strikes, go-slows, lockouts, vehicle snatching, lifting, damage to or destruction of state or private property, random firing to create panic, charging bother, acts of criminal trespass, distributing, publishing or pasting overhand villa making graffiti, or wall chalking intended to create unrest or fear or create a threat to the security of law and order. The 30th of January 1999, the Pakistan Armed Forces Ordinance of 1998 is extended to the whole country. It was also amended to enable absconders from justice to be tried in absentia by any military court. The opposition filed many constitutional petitions challenging the validity of the ordinance, resulting in Liaquat Hussain vs. Federation of Pakistan issued on the 22nd of February 1999. The Supreme Court declared the ordinance unconstitutional, without legal authority, and with no legal effect. It rejected Nawaz Sharif's claim that the ordinance was temporary and limited to Sindh province. The 27th of April 1999, repeal of the Armed Forces Ordinance. However, civil commotion is included as a crime under the Anti-Terrorism Act of 1997. The 27th of August 1999, amendment to the Anti-Terrorism Act, authorizing ATC in all of the country. Russia Yarovaya Law, South Africa South African Terrorism Act No. 83 of 1967. United States Federal Biological Weapons Anti-Terrorism Act of 1989. Executive Order 12947 signed by President Bill Clinton Jan. 23, 1995, prohibiting transactions with terrorists who threaten to disrupt the Middle East peace process, and later expanded to include freezing the assets of Osama bin Laden and others. Omnibus Counter-Terrorism Act of 1995, U.S. Anti-Terrorism and Effective Death Penalty Act of 1996. Executive Order 13224, signed by President George W. Bush Sept. 23, 2001, among other things, authorizes the seizure of assets of organizations or individuals designated by the Secretary of the Treasury to assist, sponsor, or provide material or financial support to who are otherwise associated with terrorists. 66 Fed. Reg. 49079. 2001 Uniting and Strengthening America by Providing Appropriate Tools for Intercepting and Obstructing Terrorism Act. Homeland Security Act of 2002, Pub. L. 107-296. Support Anti-Terrorism by Fostering Effective Technologies Act of 2002, Border Protection, Anti-Terrorism, and Illegal Immigration Control Act of 2005, Real ID Act of 2005, Military Commissions Act of 2006, Ohio Patriot Act.